Williams et al., case number 519395. Counsel, make your appearance.
Good morning, Your Honor. My name is Madeline Reardon.
Good morning, Your Honor. My name is Bryn Castaneda.
We represent Felix Thomas, plaintiff.
Counsel.
Good morning, Your Honor. My name is Caroline Boone.
Good morning, Your Honor. My name is Ashley Gamal.
We represent Mary Williams, defendant.
Okay, I've read the motion for summary judgment and the opposition. Let me go ahead and hear from plaintiff regarding the motion.
Your Honor, we filed this motion for summary judgment. Since there are no genuine issues of material fact that remain in this case, therefore we request that Your Honor grant our motion for summary judgment. The facts that we have are that Mr. Williams was driving an 18-wheeler and was trying to turn while in the right lane. And in that process, he hit Mr. Thomas, who was driving straight in the left lane.
Okay, wait a second. What kind of road are we talking about here?
It's like a highway. He was trying to...
A 2-lane?
Yes, ma'am.
Okay, so where, because I'm a little confused about the setup. Set me up for where the vehicles are.
The 18-wheeler was turning in the left lane while the car was driving in the right lane.
Okay, so your client's in the right lane, and the 18-wheeler's in the left lane, and goes to turn in front of the...
He's trying to make a button hook turn.
What's a button hook turn?
I'm guessing that's a U-turn. He's trying
It's a, are you guessing, or is it a U-turn?
It's a U-turn.
Okay, so a button, I'm not sure, I'm not a truck driver, so I don't know what a button hook turn is, but, so he's making a turn there, and where did he hit your client?
He hit him on the side while he was in the right lane.
Okay, on the driver's side?
Yes, ma'am.
Okay, go ahead.
Our first argument is that as soon as the wreck happened, Mr. Williams apologized to Mr. Thomas for causing the wreck and said to him, "I was trying to make a button hook turn. I'm sorry I hit you. I didn't see you."
Who said that?
The truck driver,
Uh-huh.
Mr.
I mean, but is that in his deposition? Where is that?
It's in here.
I mean, do you, I'm just asking if you have something in evidence to support that statement.
Yes, ma'am.
Okay. Is that in the police report?
No, ma'am.
It's not in the police report?
No.
Counsel, do you know where that statement is? Have you seen that statement?
It was in his affidavit.
In his the officer's affidavit?
It was in Thomas's. Yeah, it was in Thomas's affidavit.
Felix Thomas's affidavit? Okay. Are you offering that in the evidence?
Yes.
Okay, go ahead and offer it in the evidence.
Okay. According.
Go ahead and offer it in.
Oh, I would like to offer, file, and introduce into evidence
The what?
the affidavit of Felix Thomas.
Any objection to that?
Yes, we object.
Why?
Because the affidavit of Felix Thomas directly, it isn't consistent with the police report. The affidavit of Thomas says that the plaintiff's testimony says that Williams was always in the left lane. However, the police report says that he moved into the left-hand lane, then making a right-hand turn, stating that at one point in time that he must have been in the other lane.
Okay, so your argument, counsel, is that the affidavit should not be entered into evidence because it's inconsistent with the police report?
And it's hearsay. The police report is hearsay. So
And the police report is hearsay, but the affidavit is inconsistent with it.
Mhm.
I'm going to let it in because that's, I mean, the affidavit itself, even though I understand you don't like what it says, it's not consistent, that's not a reason to not strike it. So I'm going to let that in. Let it be entered. Go ahead.
Okay. According to the Avera versus Industrial Fabrication case, the law states that when you go to change lanes, you must make sure it will not cause a collision. If you happen to cause a collision, you are held at fault for the collision. Since Mr. Williams went into the other lane, he was being careless and should be held at fault according to the law.
And so your argument, according to your motion, is defendant is 100% liable.
Yes,
Is that what you're arguing to me? Okay, counsel, let me hear from you. Defendant.
Okay. The plaintiff has already stated the case, but Mr. Williams has been a professional truck driver for 21 years. and he's had training.
Let me stop you 1 second. You said the plaintiff already stated the case, so you are conceding to the facts that they
No,
gave?
like the fact that they were both driving in it was a highway, one interest.
Yeah, I
on the
mean,
highway.
I think you had a different story in your
Yeah.
opposition.
Well, the highway was a 4-lane highway going 2 different ways with no median.
Okay.
And a button hook turn is whenever you're in one lane and you go into the other to make a wider turn because
Okay.
of the large 18-wheeler. And also, the plaintiff was a trained truck driver for the Marines, so he is more aware of this procedure than anyone else, so he should have been cautious. And he was never in the left lane.
Who was never in the left lane?
Yeah.
Mr. Williams was delivering to a company on the right side of the road, and so when he pulled out onto the highway, he pulled out into the right lane, which means that Mr. Thomas would have to eventually be behind him at some point.
Mm-hmm.
Because when Mr. Williams pulled out onto the road, it was such a short gap between his entrance into
How short of a gap are we talking
under
about?
200 feet.
Okay.
And when he pulled out into the highway, he never straightened out and turned onto West 62nd.
Your client says he never straightened out. He never completely straightened out.
No.
And so if he never completely straightened out, he always had to be at least a little bit in the right lane.
He was in the right lane and he swung the front of his truck into the left lane to be able to make the right turn.
Okay, is that true? What did does your client dispute that he never completely straightened out?
Our client disputes that he was driving carelessly and did not slow down whenever he tried to complete the turn. And that just because he was so many feet away isn't relevant to why he was driving carelessly.
Okay. Well, let me ask you this. What discovery has been conducted, defendants? What discovery's been done? Depositions? Have you taken any depositions? Have you taken any depositions? I think you cited in your motion the deposition of Felix Thomas.
The affidavit of Felix Thomas.
Okay. Do you know if the deposition of Danny Williams took place yet? I'm just trying to figure out what discovery is left to be done here. This is a summary judgment.
Yes.
So the deposition of,
It's in the-
okay, so discovery is complete? All counsel, discovery is complete?
No.
No, why?
I would like to offer file and introduce the police report because this police report was done after the wreck and it was filed that Mr. Williams was solely at fault and Mr. Thomas was entirely without fault in this collision. If the police report says he was at fault, we should not have a trial. He should just have to pay the damages. Also, Mr. Thomas has been a police officer for over 15 years, so he knows the laws and he clearly knows that he wasn't doing anything wrong. He was driving straight and not making any violations.
Are you offering the police report into evidence? Go ahead and do so.
I said I'd like to offer file and introduce it to evidence.
Okay, do you have any opposition?
Yes,
Why?
we'd like to object because the police report is hearsay.
What in the police report is hearsay?
It isn't admissible.
What statement?
The statement, basically the whole police report, because he wasn't there for the actual accident, so he's going off of what witnesses said, just strictly hearsay and inadmissible in court.
What do you say to that, counsel?
I would also like say, can I offer something else?
Well, let's deal with this first. Let's deal with the police report because she's saying it's completely hearsay.
But
They're moving to strike it. I'm gonna have to strike it unless you give me some argument why I shouldn't.
If it was hearsay, that means both of the people in the wreck obviously agreed to what they offered the police officer. So at some point, the defendant had to agree with what they told the police officer.
Okay, good try, counsel, but no, we're gonna strike that police report. So I'm not gonna be able to consider anything in that, so don't include that in your argument. Do you have anything else to offer me?
I would like to offer call and introduce the document entitled Court's Minutes. It says that Danny Williams pled guilty for an improper turn, which.
He pled guilty
Yes, ma'am.
for the improper turn and that he was cited.
Yes.
So he received a citation. Did you know, counsel, did you know your client pled guilty to a citation?
Yes, this was brought up, but he doesn't recall making the statement for one that they said that,
Well, wait, let's deal with this first, because you offer filed and introduced the court minutes, correct? Do you have an objection to that? To the court minutes that show him pleading guilty?
no, I guess not.
Okay, let those be entered. Anything else?
Yeah, I'd like to make a few statements.
Okay.
The affidavit of Danny Williams directly conflicts the affidavit of Felix Thomas regarding the position of the vehicles. So this material determines fault and a court case is needed.
Okay. Well, I think you're right, counsel, that we have two conflicting testimonies here. Now, without the police report, which has been stricken, you're going to have a serious problem proving your case at trial. But I don't think it's necessarily right for summary judgment right now. So I'm going to deny the motion. Thank you.
Thank you.